In the case of Palko versus Connecticut, a man named Frank Palko was charged with first-degree murder because he killed the shop owner and was sentenced to life in prison. After the original jurisdiction in the district court was ruled, the state of Connecticut was unhappy with the decision. It became an appellate jurisdiction and was sent to the courts of appeals. Palko believed that this was going against his Fifth Amendment because he thought it was double jeopardy. He wanted to take this to the Supreme Court of the United States.
What? First degree murder? No, you want another trial.
Come back next week and we'll give it to you.
That goes against my Fifth Amendment.
Who cares?
I'm taking this to the Supreme Court.
While the Supreme Court judges determined the case to take by agreeing through the Rule of 4, they decided to take Palko's case. The Supreme Court upheld Palko's second conviction in the majority opinion. Justice Cardozo formulated principles that were to direct the court's actions for the next 3 decades. He noted that some of the Bill of Rights guarantees, such as freedom of thought and speech, are fundamental, and that the 14th Amendment's due process clause absorbs these fundamental rights and applied them to the states. All justices agreed to the ruling except with the dissent of one. Protection against double jeopardy was not a fundamental right. Therefore, the 14th Amendment could not be selectively incorporated to the right of double jeopardy. Palko died in Connecticut's electric chair on April 12, 1938. It's the year 1922, and Benjamin Gitlow is out and about in the state of New York. Gitlow was a socialist man, always wanting for the people to break free from capitalist control. One random day, Gitlow decided that he wanted to go into the city and distribute some pamphlets that would urge the people to form a socialist takeover through strikes and other forms of class action lawsuits.
Take these pamphlets. I want you to know the real about capitalism.
The real of capitalism?
The real about capitalism.
Is it scary?
Yeah, it is.
People need to know about this.
Yeah, I want you to distribute all these pamphlets. They're in here. Distribute to everyone you see. I want them to know this as well.
I will. Thank you. I appreciate this.
No problem.
Here's a beer.
Thanks.
For helping me out.
No problem. I'll drink.
The people of New York did not like this, however, and thus the Gitlow versus New York case occurred. Throughout the case, Gitlow kept arguing that his First Amendment rights from the Bill of Rights were being violated, specifically his freedom of speech. Unfortunately, Gitlow was found guilty under the New York law. Convinced that his civil liberties were violated, Gitlow appealed his case to the Supreme Court of the United States, which was led by William Taft at the time of the hearing and decision. Thanks to the Rule of 4, Gitlow's case was accepted by the Supreme Court. Because of the earlier Barron versus Baltimore decision, which stated that the Bill of Rights cannot be applied to the states, many spectators believed that the decision would be an easy one to find. The Taft Court, however, had other things in mind. They began to evaluate their interpretation of the 14th Amendment's the Due Process Clause. By the end, the Supreme Court of the United States interpreted the 14th Amendment to mean that the states could not abridge any form of freedom of expression, overturning the previous decision made in the Barron versus Baltimore case. Unfortunately for Gitlow, though, the protection did not extend to actions that could potentially harm social security. The SCOTUS upheld the decision made by New York, but also opened the doors to the incorporation doctrine. Instead of doing a total incorporation, which could have incorporated all aspects of the Bill of Rights to the states, the Supreme Court of the United States decided to head forward with selective incorporation because applying the 10th Amendment to the states felt pretty redundant. The case Barron versus Baltimore was taken as precedent for the doctrine that the provisions of the Bill of Rights are only restrictions on the powers of the national government and not on the states. Basically, this man, John Barron, was a co-worker of a very profitable wharf due to the deep waters. As the city developed and expanded, large amounts of sand accumulated in the harbor and it was ruining his business. Therefore, Barron decided to sue the city of Baltimore and take the case to a district court to restrict the eminent domain and to get compensated for the damage. He believed that this action that the city took was violating his rights stated in the Fifth Amendment. The state court found that the city had unconstitutionally deprived Barron of private property and awarded him $4,500 in damages to be paid by the city in compensation. An appellate court decision was later overturned. Barron appealed to the Supreme Court, which reviewed the case in 1833. The Supreme Court of the United States at the time was ruled by the Marshall Court. John Marshall was the Chief Justice. They stated that the Constitution nowhere states that the Bill of Rights also limits the actions of state governments.
Judge, this is the sand I picked up from my wharf that's supposed to have deep water, and now the sand is making it shallow. This is proof to you of the sand that's there.
And what do you expect me to do about this, Mr. Barron?
Well, under the Fifth Amendment, it says that I should be compensated for the damage you have caused to my business, and I want that compensation now.
No.
Why
That
not?
only applies to the Congress, the federal government, which Maryland isn't part of. Thus, the state of Maryland, through the actions of the city of Baltimore, did not infringe on the Constitution. With no federal claim, the Supreme Court thus lacked jurisdiction or power to hear plaintiff's case and dismissed it. The Supreme Court's ruling and Barron's prevailed in federal courts, however, until passage of the 14th Amendment after the Civil War. Gradually since then, the Supreme Court has interpreted the 14th Amendment, which bans states from depriving citizens of life, liberty, or property without due process of law, as also incorporating most of the amendments in the Bill of Rights against the states, including the Takings Clause of the Fifth Amendment.
Yes?
Hi, Mr. Barron?
Yeah?
Okay.
Mm-hmm.
I heard there was like a little conflict or something.
Yeah, very big
between
conflict.
your business
Yeah.
and the government.
Yeah, I lost a lot of money.
Yeah, I know, okay. And so, I'm here, part of the government,
Mm-hmm.
to give you your compensation.
Thank you.
But they told me not to give it to you.
What?
They told me not to give it to you.
Why?
Because it's mine. It's the government's. And you are left
But
with
the
your...
Fifth Amendment says.
But the Fifth Amendment doesn't... It's crap.
It says it's for the states.
It's crap. For Congress. Only for Congress.
Are you sure?
Positive.
Whatever. Get up. Get up.
Okay, I'm sorry.